All right, so if y'all are going to make me lecture, I guess I will. Talking about employment law this week. So a lot like contracts, this is something that I think that you will, number one, identify with based on your own work experience, and number two, benefit from, because this has direct application in a lot of what you're going to do if you haven't felt that already. So employment law is a mixture of federal law and state law. So if you are involved in a business, you own a business in the state of Florida, then you need to be worried about federal employment laws that apply to you, and you need to be worried about laws having to do with the state of Florida that have to do with you. The general basic employment arrangement that we start from is called employment at will. Okay, that means that an employee doesn't have a contract with the employer, and the employee is employed at the will of, at the pleasure of the employer. Another way of saying that is, in an employment at will situation, the employee can be fired for any reason that's not illegal. I have an employment contract with CSU, but if I didn't, and Dean Kidder decided that she didn't like the way I walked across the street, she could fire me for that. That's not illegal. If Dean Kidder decided she wanted to fire me because I'm a Georgia fan and she is an Auburn fan, she could do that if I'm an employee at will. Anybody that has a contract takes you out of employment at will status. And the terms of your employment are governed by not just what the laws are, but what your contract says. Anybody in here have an employment contract? You do, Mike? Is it for a certain amount of time? Okay. Does it specify your rate of pay? Does it specify your job duties? Does it specify the things that you could be fired for? Okay. So if your employer comes in tomorrow and says, I don't like the name Mike, you're fired. If that is not a reason that's in your contract and it's not illegal, then that employer can do that. Anybody in here an employee at will? Meaning you work for somewhere, but you don't have a contract. You're both? Okay. Two different jobs? All right. What is your what is your employment at will job? Okay. So you work at a bar and you walk in tonight for your shift and they're like, we don't like you anymore. You're fired. Happens all the time, right? Khalil, you're still at Best Buy. You didn't sign an employment contract, did you? Or do you? Okay, you're an employee at will. Sometimes the line can be a little bit blurry because I'm going to bet, Khalil, that when you did your onboarding, you signed a whole bunch of pieces of paper saying, this is the code of conduct, this is the expectations, all this. That's not necessarily an employment contract, but you have to be careful because some employees would make the argument in court that that amounts to an employment contract. You are an employee at will in Georgia, but there might be some jurisdictions that would accept that the more things you've signed, the more that you and your employer have agreed on in writing, the more that looks like a contractual relationship and less like an employment at will situation. Who else is employed at will? Patrick, what do you do? Okay. All right. Who else? Anybody else have an employment contract? Nope. Okay. Well, you've probably all been employees at will at some time or another if you have had jobs during your careers. Ken, you're a contractor now, right? I mean, you work for a government contractor?
No, I work for the government directly.
You work directly for the government, but not under a contract?
No, I want to.
Okay. But now you're at will?
No. Well, no, it's a bit different because it's federal government.
Right.
We took a supervisor position, so I used to be classified as what they call a bargaining unit employee, which means I was part of the union with me. Now that I'm a supervisor, I'm a non-bargaining employee.
No, but I'm glad you brought that up because we don't really get into labor unions in this class, but that is, if an employee is a member of a union, a recognized union, and that union has a contract with the employer, then there are volumes of rules and agreements between the employer and the union about promotions, hiring, pay rate, hours, conditions, benefits, all those sorts of things. So that's another source um, of obligation for an employer. So somebody who is maybe doesn't have an employment contract, but they're part of a union and they're working under a union contract, that would take them out of the employee at will realm. I'm glad you brought that up. That's a good example. We don't really labor unions are there's just so much to that would be a uh, whole nother class almost. This class looks more at what you would think of in terms of like human resources and your discrimination in employment and things like that.
Can you touch on in this section, chapter, whatever, can you touch on the lines of that will, what is it, state unemployment at all?
Yeah. Question is, are we going to talk about unemployment? Yeah, we are going to talk about that. So that's our starting position, is that most employees are employees at will unless they have a contract, unless maybe there's a union involved. Um, that is how that works. Now, when I said they could be fired, an employee at will could be fired for any reason. The qualification I put on that was as long as it's not illegal. So there are a bunch of laws, and we're going to talk about them in depth in here, that say what is illegal, what it is illegal to fire someone for. Discrimination on the basis of a whole bunch of different characteristics is illegal. It is illegal, for example, for an employer to fire somebody for whistleblowing. Y'all familiar with that? Reporting something illegal that your employer's doing. Most states and the federal government have laws that protect whistleblowers from being fired for that, even if they're at will. The whistle, I don't know the exact name of it. It could be, and I think there are multiple ones that I'm not sure that there's one that's just blanket for everybody. I think it may be by sort of sector, but I'm not sure on that. It's a good question. So some states will also pass their own laws against wrongful discharge, and they may establish other reasons that make it illegal to fire somebody. That's going to be on a state-by-state basis. Again, the federal laws apply to everybody, and then each state may have some additional requirements. So for a second, let's jump to wage and hour law and leave for a second. So there are more than one federal statute that apply to wages and hours, setting what the law is with regard to what you pay somebody and how long and what conditions they work under. Pretty much by now, every employer is covered by minimum wage laws. The minimum wage is currently $7.25, and it hasn't been raised in 15 years, which is astounding to me. The states are allowed to set minimum wage levels that are higher than the federal minimum wage. You can't go lower than that, but you can certainly go higher. And the last time I checked, I think New York State and maybe Washington State and maybe even some cities within those states had passed their own minimum wage that was up somewhere around like $14 or $15 maybe. California, yeah. And so the $7.25 minimum wage is really antiquated. Um, I would say I would expect that to be raised, but I hadn't been raised in 15 years, so who knows? But maybe states are kind of taking care of that on their own. The wage and hour laws, primarily a law called the Fair Labor Standards Act, FLSA, that talks about um, minimum wage. It talks about child labor and the types of jobs that it's okay for minors to work in. Depends on your age, depends on how dangerous it is. We're not getting all the way down into the weeds on that. And it covers things like maximum hours and overtime. So, has anybody ever had experience with overtime? Overtime is awesome when you get that paycheck, right? Not so much fun when you're working extra hours, but when you get it, you're like, dang. At least that's how I was anyway. So overtime rules are that if you work more than 40 hours in a week, then you get paid your hourly rate and a half, time and a half. So easy example, my hourly rate is $20 an hour and I work 50 hours. I'm going to get $20 an hour for the 40 hours and I'm going to get $30 an hour for the extra 10. Okay? And that is the law. So if you believe that you are ever in a job where you are working overtime and not getting paid for it, then that's something you'd need to raise with your employer. So yes, Khalil.
Oh, I don't think that. I just know that with overtime, like both the jobs that I had, they are very strict on it. Like
They don't want you to get overtime,
yeah.
right?
Like I mean, sometimes it's necessary for like
Yeah.
but like they hate having like that's why
That costs the employer a lot to pay overtime. So they better be getting something out of it or they better be in a bind where they just got to suck it up and have something done, right? Not everybody is entitled to overtime, and this is important for you to know the distinction too. There are some employees who are exempt from overtime, meaning they don't get it even if they work more than 40 hours in a week. Those are employees whose primary duty is management, whose primary duties involve independent judgment, discretion. They're salaried employees. Okay, if you're an hourly employee, you are not exempt. Most salaried employees are exempt. Where you have to be really careful as an employee or as an employer is that you're classifying your employees the right way. The federal government doesn't come in and say, Mr. Kane, your factory has 500 workers. We'll tell you which ones are exempt and which ones aren't. You decide which ones are exempt and which ones aren't. Now, there are guidelines in the law that tells you which ones should be and shouldn't be, but you choose. And if you choose wrong and the employee brings it up or the federal government comes in to check on you, then you could be in trouble for it. Point being, I don't want y'all to ever be railroaded or pushed or influenced into a job where your employer tells you you're exempt from overtime when you're really not. They might be just trying to classify you as exempt so that they don't have to pay you overtime. On the other side of that coin, if you're an employer, you need to make real sure that you've classified your employees correctly. Because the last thing you want is to have federal government in your business doing an audit of your wage and hour situation and find out that you've misclassified some people, and not only do you owe them back overtime, but you owe them some penalties or fees or interest or something like that. So lesson being, don't take your employer's word for it about whether you're exempt or not. If they try to tell you you're exempt, then you need to make sure that that job truly is exempt under the way that the Fair Labor Standards Act defines exemption. Family and medical leave. Anybody ever taken family and medical leave? You have, Surrey? How many weeks? 2 weeks. All right. The Family and Medical Leave Act, FMLA, moving to a different law now, says that an employee may take off up to 12 weeks in a calendar year for certain things, which we'll talk about in a sec. You have to be employed by your employer for 12 months before you can qualify for family and medical leave. So if I got hired at CSU for this semester and I needed to take medical leave, I'm not entitled to that yet under the law. I haven't been here long enough. Once you hit that year mark, then you're entitled to take family and medical leave. Family and medical leave in this country is, I'll be interested to see what y'all think. This is the subject of the article that I assigned y'all to read in your discussion question. Other countries have leave provisions that are much more generous than ours. So ours is, the FMLA says that you can have 12 weeks of leave, but it's not paid. The guarantee is, you have a couple guarantees. One is that if you have health insurance through your employer, they have to keep your health insurance in place while you're on leave. They can't cancel that. And they have to guarantee you that when you come back, you will have a similar position. Not your exact position, but a similar position. There's some exceptions for key employees who are like in the top 10% of your pay scale, like maybe some of your like CEO level type stuff. You might not have to leave a CEO job vacant for, you might not be guaranteed to put them back in that after 12 weeks, but generally speaking, you're guaranteed to return to a job with similar benefits and responsibilities. So that's the law doesn't define it further than that. So let's say that, Zuri, when you came back after 2 weeks of leave, did you get the exact same job? Okay. What were the general duties of your job? Okay. And what business was it? Foot Locker. Okay. If you were, you did stocking and sales, cash, that kind of thing. If you came back and your job all of a sudden was maintenance, you might have a good argument that that's not similar to what your job duties were before. If you came back and they made you stay in the warehouse full time, then you might think, well, that's part of my duties before I left. So that part is similar, but I'm not getting to do the sales and cashier part. So that's not similar. That's a little bit more muddy. It's just going to depend on the facts of each case. So what is a similar position can have a bunch of different variants to it. When you came back, did you get the exact same rate of pay? You got a pay increase. All right, well, excellent. Definitely shouldn't be getting a lower one. But if we're comparing similar, let's say that and we're just making this up, obviously. Let's say that Dean Kidder pays me $1 million to teach business law, and I need medical leave for half the semester. When I come back, she's going to pay me $500,000. That's still a very good compensation rate, but is that similar to what I was getting paid before? No, that's 50% of it. So even though I have the same duties in terms of what my job is, I might can make the argument that that's not a similar position if I'm taking a 50% pay cut. If somebody's making $8 an hour and, well, that's not a good example. If I'm making $1 million and I come back and the pay is $950,000, I'd have a little bit harder time making the argument that was not similar, although I would make it. I don't know if I would win it. So what can you take family and medical leave for? You can take leave to care for a new child, adopted or newborn. You can take family and medical leave to care for a foster child. The adoption and foster care has to be within 1 year of the child's placement. You can take leave to care for a seriously ill spouse, parent, or child. You can take medical leave to care for yourself if you have a serious health condition that prevents performing essential job functions. Now, hopefully, if I've taught y'all anything in this class, you hear me say something like, to care for themselves if a serious health condition prevents performing essential job functions. What does that scream out to you? Where is this stuff going to get sorted out if we have disagreement? In court. That screams out litigation, doesn't it? What is a serious health condition to me versus a serious health condition to John? What prevents me from performing essential job functions? Which job functions are essential? Those are all areas that could be up for argument. And then the last one is to deal with any non-medical emergency arising out of the fact that the employee's spouse or child or parent is covered on active duty. I mean, is that person is on active duty with the military. So if my son was in the Army and he got deployed, and I needed to watch his son for a couple of weeks while he was gone, or he gone to a training and I had to provide childcare, that might qualify as family and medical leave. The bigger your company is, the easier it is for an employer to cover an employee being out on medical leave, right? You got more people that you can divide up their duties between. The smaller you are, that's more slack that everybody else is having to pick up. So it's a little bit difficult for smaller ones. The limit is, I'm looking in my outline that I forgot to print out today, and 50 employees is the cutoff for whether or not the employer is required to give medical leave, family medical leave. So because of the reason I just explained, say my business is me and one assistant. If she needed to be out for 12 weeks, I couldn't function. And so the family and medical leave does not require me to give it to her because I don't have 50 or more employees. So smaller employers are protected from that. Another way to look at that is that employees who work for smaller employers are not protected because they don't have access to family and medical leave. A person can also take up to half a year to care for a family member who was injured on military duty. So that's the only way you really go past 12 weeks. Again, it's unpaid. The article that I assigned you to read for this week talks about some countries that have paid medical leave. They force the employers to pay. Like it's the law. The employer doesn't have any choice. If the employee qualifies, has a reason for, going out on medical leave, then they get paid. Germany, yeah, the European ones are the ones that are the most generous that I know of. I think the Scandinavian countries are super generous. Mm-hmm. They would send you to a resort for a week? Oh, paid vacation, basically. So I'm not sure where I fall on that because I see a lot of both sides of it. As an employer myself, I don't like the idea of the government telling me I've got to pay people who aren't coming to work. But when I think about a big company who it's not going to really dent their bottom line, I like the idea of employees having that benefit. But the cynic in me thinks that if the government said it's mandatory that you pay your employees for 12 weeks of leave a year, how many weeks of paid leave are my employees going to take each year? 12 weeks for sure, right? John's already thinking, he's just thinking like, oh, I definitely would find a reason to take 12, right? Weren't you? You'd be stupid not to, see? So that's a way of shifting that shifts the burden to the employer. And I guess that depends on how you feel about the role of government and so on and so forth. So that's kind of one of the questions that I'm asking you to mull over in your discussion this week. Maybe there's a sweet spot in there between what some of the European countries do and the harshness of what we do. Yeah, no doubt there's a difference in culture and work culture. Hours, how hard you work, how many days a week, what time you quit, whether you can take a 2-hour nap every day at lunch.
And they pay much higher taxes. Somebody might say,
Right.
they're more socialist.
Right. And it could be that their government is subsidizing those employers and that really it's coming back out of the employee's pocket in taxes. I'm not smart. I haven't studied it in depth enough to know. I'm sure there's some trade-offs with that. So that'd be an interesting thing for that I'm interested to read your opinions on. All right, that was wage and hour law and leave. So let's jump to the next section, which is health, safety, and income security. Ken, do y'all have to deal with OSHA? Is it a pain in the butt or is it not a problem? I bet when you worked on post, OSHA was a pretty big part of what y'all, or being OSHA compliant was an important thing. So the question is, what kind of things did OSHA get in your business about?
All your training equipment.
Training, safety. I worked at a facility that repaired tanks, real vehicles, eye wash stations, operating, everything you can think of. Not using the proper PPE.
All kind of safety stuff, right? So remember at the beginning of the semester when we were talking about administrative law and how executive agencies like OSHA set rules, they make rules that have the effect of law. And I think we looked at some of those and it was stuff as picky as like if you have a ladder, the rungs cannot be this far apart. The load bearing on the ladder has to be this. The hinges have to be replaced every so often. I mean, it's super specific. If I had a job if my job was to make sure that we were OSHA compliant, that would be a tough job, I think, because of how picky and the minutia of the safety regulations. So the Occupational Safety and Health Act is the statute that goes along with the Occupational Safety and Health Administration. That's the agency that oversees workplace safety, and they're responsible for carrying out the Occupational Safety and Health Act. That makes sense. OSHA, the agency's responsibility is to carry out what OSHA, the statute, says about workplace safety. They work hand in glove that way. It has not only to do with complying with the physical environment, but with record keeping. How often you checked your ladder to make sure that the hinges have been replaced, or that you tested your ladder to make sure the load bearing was appropriate. Did you measure the space between the rungs in your ladder? Your eye washing stations, like Mr. Marshall said, all those type of things. It's not just the providing it, but it's the record keeping on it as well. You got to report to OSHA if somebody dies or if you have a certain number of people hospitalized. They're just very much in the business of workplace safety, of the employers and their workplace safety. Employees can make complaints to OSHA. They could come in and inspect. They can do inspections on their own anyway. Most of them, how often were y'all inspected, Ken? Was it regular or random? Yeah, reporting injuries. Do you run into OSHA at the bar?
I run it at my EMS job.
Your EMS job, I bet you do. Yeah. Medicines, waste, chemicals, cleaning.
That's also the infected employees.
What vehicles? Vehicle maintenance, all that kind of stuff. It is extensive. It is extensive. Workers' compensation laws. Anybody have any personal experience with a workers' comp? So here's how that works. If an employee gets hurt on the job, they have some choices. They could sue their employer if it's the employer's fault for negligence, or if it's intentional, for an intentional tort. This goes back under tort law. Or the employee could use the state's workers' compensation program. And the workers' compensation program, it's state by state, so Georgia has its own. And it pays benefits to anybody who's injured on the job. You don't have to prove, it has to not be your fault. But you don't have to prove that it was the employer's fault, that they were negligent, they did something. You get hurt on the job, you get paid under workers' comp. The trade-off is if you choose to use workers' comp as your compensation mechanism, you give up your right to sue the employer. So you can't have it both ways. You can't sue your employer and go collect workers' comp. If your injury is bad enough that you think you can sue your employer and make better bank that way, then you would do that. But most minor injuries, it's easier for an employee to go ahead and use workers' comp, get paid for it right then when they need it, and not maybe wait the length of time that it would take a lawsuit to resolve. You sue your employer for something, that's going to get, most likely that's going to get stretched out a pretty good bit. So that's how workers' comp does. If you're like me, when you look at your paycheck in detail, you see all of the contributions that you have to make based on federal income security laws, right? All the stuff that gets withheld, not just your federal taxes, but your Social Security. That's a federal law that requires that money come out of your paycheck, contributes to your Social Security account. When you reach a certain age threshold, you can start drawing it back. Medicare, similar to that, a lot of what you're paying in now as part of income security goes to getting health insurance in the form of Medicare when you're of retirement age. That's certainly better than having to buy your own health insurance at that point. But we're paying now for our retirement checks and our insurance when we're retired. If it's still, it better damn be there when I retire, right?
What do you do if you've been taking it out of your money this whole time and they take it away? Like, do you think everybody can get like
I think that if for some reason the government if they defaulted on their obligation under the law, they'd be liable. Every worker could sue them for it. Yeah. It's not guaranteed, Travis, but I would think it's probably pretty close to it because it's the law. It's vested. They can't take it away. If they ever change Social Security, it would have to be going forward. We'd all be grandfathered in for what we had contributed, I would think. But that does worry me sometimes. But then again, it falls under the category of things that are over my head that I just can't use too much energy worrying about. Unemployment. I know we asked about this earlier. So unemployment is a benefit that is paid on the state level, and it is paid for employees who lose their job through no fault of their own. Long as you didn't get fired for a cause, then you can apply for unemployment and you'll get those benefits for however long they ask. I think there's a federal component to unemployment too. That's was going to say free. It's paid for because employers pay unemployment taxes to the government. It just goes into a big fund that is then used to pay out unemployment benefits to people who lose their job. During COVID, that got extended. Some people who were unemployed got longer than whatever. I think it's 6 weeks. Anybody have any experience with that? I think it's up to 6 weeks. But the idea is, unlike Social Security, where I'm paying in to Social Security that I'm going to draw when I retire, I'm not personally paying in to the unemployment fund from my pay that they're withholding. My employer is, CSU is, but I'm not. Mm-hmm.
Yeah. So it's like an account or form you submit, and then they give you like a stipend, and you have to claim the stipend every week.
Yeah.
So it's like, I forgot what day it is, but it's like this day to this day you didn't work,
Right.
and then they send it.
And then it's basically getting paid while you're trying to find another job, I guess is the theory behind it. I do know from personal experience that employers get their unemployment tax rates can go up the more they have employees who use unemployment. So like if I'm always firing people for no fault of their own and they're going to the state of Georgia and getting their unemployment insurance, then the state's going to look at me and say, Tebow, you're part of the problem. Your employees are the ones using this all the time. So we're going to up your contribution rate and you're going to pay maybe more unemployment taxes than somebody who doesn't lose their employees. Obviously, the bigger you are, the more employees you're going to have more turnover and so on and so forth. But I know one time, it's the only time I've ever had to fire somebody in my whole career, she claimed unemployment and we had a dispute over it because I didn't want my unemployment. One of the reasons, well, we had a dispute over it because she was watching Keeping Up with the Kardashians all day long and not doing work. So I felt like there was cause for it. But the other reason was I didn't want my contribution to have to go up. I didn't think it was fair for me to be paying higher unemployment taxes because another person wasn't doing their job. The state didn't see it that way. I lost that argument. Ken, did you have a comment?
So, typically, that you just answered, that's paid out by the state.
Yeah, employers pay into it.
So if a person were to get fired and then move out of state immediately after, I would think, you may not know, but I would think they wouldn't be able to.
You get fired and then you leave the state. I'm thinking that you would probably be entitled to it as long as you were in the state when you lost the job. I'm betting. I don't know though. That's a really good question. Would Georgia be mad if I moved to Alabama 2 weeks into my unemployment and I'm living in Alabama but collecting from Georgia? I'm thinking Georgia would still have to pay because that's where I was employed. And it still wasn't my fault that I lost the job. That's the argument that I would make. But I'm not totally sure on the exact intricacies of how that works. Another good benefit is COBRA. I say it's good. Anybody have any experience with COBRA? COBRA is, let's see, it stands for Consolidated Omnibus Budget Reconciliation Act. That doesn't describe what it does. What COBRA does is it says that when you lose your job, whether it's your fault or not, and you have health insurance through your employer, they've got to keep your health insurance in place for a certain amount of time. Trade-off is you got to pay for it. So if CSU fires me today, I'm at least guaranteed access to my CSU health insurance for, I think it's 6 months. But I've got to pay for it. They're not required to keep paying for it. And that just guarantees me the access to some sort of health insurance. Maybe CSU doesn't know it. They fire me, but I've got just got diagnosed with cancer. It's going to be hard for me to go and get another health insurance plan because now I have cancer. Nobody's going to want to cover a pre-existing condition. So that guarantees that I can continue being covered so long as I pay for it. It's usually not a good deal in terms of what it costs you. It's not a great deal for the employees. Most of the employees will do it if they have no other choice and they need to. Most people, you could get another job and then use your health insurance at the new job, or you can go out in the marketplace nowadays and get a health insurance policy that's reasonably, well, I don't want to talk about that. That's what I think about the cost of health insurance in the marketplace. But COBRA is usually not a great deal financially. All right, that brings us to employment discrimination. So we're going to spend a good amount of time on this. We'll do this the rest of this class period and mostly into Thursday. But there are, just like there are state and federal laws that govern the things we talked about so far, like income security and medical leave and reasons for wrongful termination, things like that. Same thing applies to discrimination in employment. Most states don't have real extensive employment discrimination laws because the federal law is pretty extensive. There's not a lot of area for them to go and pick up slack in. So we have several different statutes we're going to talk about. So for example, I'm just giving you an overview right now. We're going to talk about Title VII of the Civil Rights Act of 1964. Title VII is what that's most commonly known as. Probably what, if you've heard of it, that's what you've heard of. Title VII prevents discrimination on the basis of race, color, national origin, religion, gender, and sexual orientation. Age is covered by the Age Discrimination in Employment Act. So that's another protected class under that law. And then we also have the Americans with Disabilities Act that adds another protected class for anybody who has a disability. And the definition of disability is pretty dense, so we'll look at that. We probably won't get to that till Thursday. But my point in giving you an overview on all this is that when we say protected class, that is a class of people who can't be discriminated against in the workplace. It's illegal to discriminate based on anybody who is in a protected class. So when I talk about protected class, I'm talking about all the ones that are named under Title VII. I'm talking about age, because that's under the Age Discrimination Employment Act. I'm talking about disability. We can group those all together for our purposes, even though they're covered by different laws, because they're treated kind of the same. We can even break down protected classes even further. When I say national origin, that is, we most associate that with a person who's born in another country or whose ancestry comes from another country. But it's as broad as someone who's regarded as being from another country or whose ancestry is from another country. So I might not actually be from South Africa, But if my employer thinks I am and treats me differently because they have the erroneous belief that I'm from South Africa and that was the reason for them not hiring me or firing me or treating me in some discriminatory way, then national origin would cover me. I'd be a member of that protected class. So race, obviously, age, religion, national origin. Sexual orientation is interesting in that up until a few years ago, appeals courts had held that Title VII did not include sexual orientation as a protected class. There was a DFACS employee from Georgia, from Clayton County, Georgia. Anybody from Clayton County? From Clayton County, Georgia, named Gerald Bostock. And he claimed that he was fired for being gay. And he sued the state of Georgia. Or he sued Clayton County, state of Georgia. And his argument was, you fired me because of my sexual orientation, and that violates Title VII. Well, Clayton County went to court with all the previous cases and all the precedent from courts that said Title VII does not include sexual orientation. It made it all the way to the Supreme Court, and the Supreme Court said, now it does. Now we read that law as covering sexual orientation. Just like how in Brown versus Board of Education, the Supreme Court overturned previous precedent having to do with segregation in schools. It's only been about 6 years since the Supreme Court of the United States overturned the previous precedent and said, this law, we do read this law as covering sexual orientation. It came out of Georgia. Now, you'll see, I actually have assigned you, I do assign you this case. It's for next week. But since I'm talking about it, one of the things that the dissenting justices said, the justices who said, that's not what the law says, they didn't say we don't think sexual orientation should be a protected class. We just think that it's not the court's responsibility to read it into the law. It's whose responsibility to put it in the law? Congress, right? That was their argument is, yeah, this class of people should absolutely be protected from discrimination in the workplace, but the courts shouldn't be the ones that are rewriting laws, basically. If the legislature wants to have Title VII to cover sexual orientation, all they've got to do is pass the new law and say Title VII includes sexual orientation. So we read through all that next week, and it's sort of an interesting case, in my opinion.
I wonder if there was similar dissent to the Brown Board of Education.
I'm thinking back to that case, but without going back and look, it's not fresh on my mind because we did it so many weeks ago. But a lot of times dissents do rely on that type of reasoning that we've got. Our job is to decide if a law is constitutional or not. It is not to write the content of laws and read things into them that the people whose responsibility to write them didn't put in there. That's a debate that's been going on since the beginning of our country. So employment discrimination, how does it work? So, like most things with our government, the federal government has set up an agency that is tasked with overseeing discrimination in employment. It's called the EEOC, the Equal Employment Opportunity Commission. Y'all have heard of them? So they have their job is to carry out Title VII and enforce it, but they do that in many ways. So if an employee feels that he or she has been discriminated against in violation of one of these statutes, the employee is a member of a protected class, suffers some sort of adverse employment decision. I didn't get hired for a job I applied for. I didn't get promoted. I got fired from a job, if any of the reasons behind that are discriminatory, then before that employee can sue the employer, they have to file a complaint with the EEOC. You got to go there first. And it's not a real efficient scheme, I would say, but it serves a purpose in this way. If we just allowed every employee who wanted to sue for employment discrimination to sue, that would clog up the courts pretty fast. So by putting this EEOC scheme in place, it filters them out somewhat. So you got to go through that first. You make your complaint, the EEOC will look into it. That requires the employer to send something back to the EEOC saying, here's the reasons why this person was not hired or fired or disciplined or whatever the action was that they encountered. And then the EEOC will either find that you have cause or no cause, but no matter what they find, they still give the employee what's called a right to sue letter. So the EEOC process never keeps an employee from going to court. You don't get stopped there, okay? But a lot of employees who go through the EEOC process learn by reading what the employer writes back, ooh, I really don't have a very good case. Maybe I'm not going to actually sue. It would be harder for an employee who had a weak case get exposed through the EEOC process to find a good lawyer to handle their employment discrimination case. If I do employment discrimination cases and somebody comes to me and they have gone through the EEOC process, they got their right to sue letter, now they're ready to find a lawyer and sue, and I look at all their EEOC stuff and I see what the employer wrote back, and I see that the EEOC has not found there's been any big problem here, I'm not going to waste my time taking that case. So it does act as a screening mechanism of sorts without depriving the employee of the fundamental right to sue their employer if that's what their heart is set on doing. Another thing that the EEOC can do through this process is there'll be certain cases that they see from complaints that are made that are awful. And the EEOC could decide to sue for the employee. Lots of times that'll happen if it was egregious or if what happened to this employee affected a large class of employees and the EEOC would like to do it on behalf of hundreds of employees who this happened to. That makes more sense for them to get involved in suing the employer themselves instead of letting the person do it. Maybe the EEOC wants to make a statement or prove a point or make an example out of somebody. That might be another reason why they would decide to take the case. But no matter what they do, even if they don't decide to take the case, even if they find there's not a lot of merit to the complaint, they still issue the right to sue letter to the employee. So they can still go to court if they want to. So that's kind of how that works out. So I'm trying to decide if I want to dive into this next section or not, based on the time we have. Yeah. Let me just mention for a second the mechanics of how an employment discrimination case works once it gets filed, once it's in the court system. So when we talked at the beginning of the semester about the court system in general and how the plaintiff, I'm sorry, Annabeth? We are on, I am in Section 5, Employment Discrimination. You'll see Title 7 of the Civil Rights Act. And then if you go down to number 3, intentional discrimination, establishing a prima facie case. See that? Okay, that's where we are. So normally, in most cases, the plaintiff, person who files the case, right, against the defendant, it's up to the plaintiff to carry the burden of proof in the case. It's the plaintiff's responsibility to convince the judge or jury that they should win or they should recover or that they should get the relief they're asking for. In a criminal case, again, the prosecution is the government, and they have to carry the burden of proof of beyond a reasonable doubt that the defendant did the crime. In a civil case, the plaintiff would have to prove by preponderance of the evidence that the defendant was liable of discrimination in employment in this context. In employment discrimination, the burden of proof kind of hops back and forth between the plaintiff and the defendant, unlike it does in the examples I just gave you. So in an employment discrimination case, the plaintiff employee is going to sue and say, I was discriminated against in my job based on me being a member of X protected class, and it was discrimination. All right? The burden of proof then shifts to the defendant temporarily to explain to the court what the reason was, to provide what's called a legitimate, non-discriminatory reason, if they have one. If they don't have one, I would suggest that this case is getting settled somewhere before you get to trial. But once you get to the courtroom, that's what's going to happen. So I say, incidentally, anybody know what the cutoff is for age discrimination under the Age Discrimination Employment Act? How old do you have to be covered? 40. Turn 40, you can't be fired for being old. So I'm over 40. Let's say that CSU fires me, and I think it's because they think I'm old, that I'm past my prime. And so I sue them, right? I bring an employment discrimination suit. I sue CSU for employment discrimination under the Age Discrimination Employment Act, and I say, you fired me because I'm old, and that is illegal. The burden's then going to shift to them to articulate to the court what the real reason was. There may be a real reason, okay? Maybe they found out that I was convicted of robbing the Circle K on University Drive, and they decided that that's not appropriate for a professor to be an armed robber. Maybe they say, you had the worst, what's that website? Rate My Professor. You had the worst Rate My Professor score of all time. 100% of the students that took your class said you were the worst they'd ever had. All right. You came to class drunk. I didn't do that. Maybe they have a legitimate, non-discriminatory reason. If they do, now's the time for them to say it. Once they put that reason forward, then the burden comes back to the plaintiff. And the plaintiff then has to prove that wasn't the real reason. That was a pretext, a false reason. And the real reason was discrimination. Okay, so it's a little bit of a burden shifting there. I bring the suit and allege discrimination. The defendant has to put forth a legitimate non-discriminatory reason for the employment action. Then it goes back to the employee to prove that the reason that was offered was false and that the real reason was discrimination. And that's kind of how the mechanics of it work in the courtroom. On Thursday, we're going to talk about different types of discrimination. We're going to talk about the Americans with Disabilities Act. And if I finish, I'll read you some employment discrimination scenarios, and we'll talk through whether or not the employer's done anything wrong, kind of like we did with the contracts and kind of like we did with criminal law and tort law. Anybody have any questions?
Real quick.
Yes, sir.
When you bring the suit for discrimination, you don't have to provide anything at that point, you just make the allegation.
You do have to provide enough facts in your complaint to say what the discrimination is. But it's not The burden is not put on you for the rest of the case to prove it until they have said what their reason is. You're entitled to get that kind of first. Good question. All right, I'll see y'all Thursday. Everybody go to Theo.